So session 2 of the Borden-Ladner-Gervais courtroom of the Walker Supreme Court is now in session. It is with great honor and privilege that I present Justice Kirsten Crane, BLG, Justice Daniel Chomsky, Gowling, Justice Jennifer Chandler, English Common Law Faculty, and Justice Tara Lemke, Williams Litigation. Justices of the panel, I present to you, speaking on behalf of the appellant, Ms. Armstrong, in today's manner before the court, Emma Aggett and Tony Pascale. And speaking on behalf of the respondent, Dr. Ward, Sean Ovas, and Samantha Iantomasi. We are here today to determine the outcome on appeal before the court on the matter between Ms. Armstrong and Dr. Ward. Both the appellant and respondent counsel will have 30 minutes each in total, 15 minutes each council member to present their arguments, including answering questions from the bench. The appellants will present their arguments first, followed by the respondents, and then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there is 5 minutes left per speaker. Appellants, will you be using your 3-minute rebuttal?
Yes.
Okay, thank you. So the court now invites counsel for the appellant to begin.
Thank you. Good morning, Justices. My name is Emma Aggett, and I'm counsel for the appellant in this matter, Karen Armstrong. Our submissions today will demonstrate why the Court of Appeal in this case reached an incorrect finding that the trial judge erred in his articulation and application of the standard of care. I will be dealing with the first two issues of requisite standard of care and duty to rule out non-negligent causes. My co-counsel, Tony Pascale, will then make submissions on causation and standard of review. Altogether, our submissions will demonstrate why the court should set aside the judgment of the Court of Appeal and restore the trial judgment with cost throughout. My submissions have 3 main points. 1, the standard of care for medical practitioners in Canada is clear, and the trial judge correctly defined the standard of care based on the evidence provided to him at trial. 2, the trial judge was not using a goal-oriented approach in defining the standard of care. It is our submission that goals and steps are purely semantics in this case. And 3, the plaintiff does not have the duty to rule out all possible non-negligent causes. My first point starts with this honorable court's holding in Terneuzen versus Korn regarding standard of care. It is well settled that physicians have a duty to conduct their practice in accordance with the conduct of a prudent and diligent doctor in the same circumstances. In this case, the trial judge was asked to determine what that specific conduct would entail. Based on expert testimony of 5 medical professionals, including Dr. Ward himself, the trial judge appropriately concluded that identifying, protecting, and avoiding direct contact or close proximity to the ureter are essential steps a surgeon must take in conducting a laparoscopic colectomy. Our friends make reference to several cases that suggest Dr. Ward was not negligent in his actions. These cases are all distinguishable from the case at bar. Beginning on page 10 of the respondent's factum, Hobson versus Monkley is referenced, where the court found the mere fact of occurrence of injury does not give rise to the right to recover damages. Now, Hobson is a case where we see the surgeon non-negligently damaged his patient's ureter during surgery. I would first like to note that this surgery was not a colectomy, it was a tubal ligation. Neither the patient nor her doctors were aware that she had endometriosis until the actual surgery. The plaintiff in this case had a large cyst that was discovered during surgery, and the doctor made the reasonable decision to remove it, which expert witnesses testified could have resulted in the ureter damage. The expert evidence in this case for both the plaintiff and defense agreed that the surgeon acted reasonably in the circumstances. Now we know this obviously differs from the case at bar, where Miss Armstrong had an anatomically normal colon and ureter, no history of relevant medical conditions which could have interfered with the surgery, and no complications discovered during the surgery. Our friends next reference Campbell versus Fairley, another case where the defendant doctors were held not liable for damage to the ureter. This case, unlike the case at bar, was a vaginal hysterectomy, and the instrument used to do the surgery was a harmonic ACE scalpel, not a ligature. Surely the standard of care in these cases are distinguishable. Our friends submit that the trial judge accepted Dr. Ward took required steps to meet the standard of care, and thus should have resulted in a finding of non-negligence. With respect, this is simply not true. The trial judge heard multiple expert witnesses and established steps required to meet the standard of care based off their testimony. The trial judge explained at paragraph 109 that he was satisfied that Dr. Ward took steps during this laparoscopy to identify and protect the ureter. Took steps, not took all steps. This is because the trial judge had one more required step: identify, protect, and avoid direct contact to or close proximity to the ureter. Close proximity meaning 1 to 2 millimeters. The trial judge rejected Dr. Ward's argument that he stayed at least 5 centimeters away from the ureter at all times. He provided 2 explanations as to why he rejected this argument, both completely supported by the evidence of the expert witnesses, which I will touch on later in my submission. Moving to my second point, the majority of the Court of Appeal found that the trial judge erred in focusing on goals rather than the means to achieve goals in performing a colectomy. Our friends submit that the use of the word goal was inappropriate, as it implies a standard of perfection, which my co-counsel will address more in depth during her submissions. We respectfully submit that the trial judge's use of the word goal is purely semantics. Goals and steps can be used interchangeably when describing what one must do in a surgery. Of course, there are steps a surgeon must take in a specific surgery. Completing those steps successfully can be described as a goal of the surgeon. I'll echo Justice Van Rensburg in dissent when I say that throughout the trial, staying away from the ureter was consistently described by the witnesses as a step that Dr. Ward should have taken and not his goal. This was clear. My third and final point is that the plaintiff does not have the duty to rule out all non-negligent causes. This theory would create an infinite amount of duties on the plaintiff, from earthquakes to muscle spasms to the hospital losing power mid-surgery. If these non-negligent theories are not argued by the defendant, surely we can assume that it is because the evidence didn't support that they actually happened. Not to mention that in medical malpractice cases, the defendant is surely in the best position to bring non-negligent theories forward, considering that the plaintiff is often sedated and often does not have the expertise to know what is happening regardless. Our friends submit Edgar versus Johnson as a similar case to Ms. Armstrong's. Our friends say that Edgar demonstrates that a plaintiff is required to disprove all non-negligent causes. This case is distinguishable as the sole issue was causation, and the doctor maintained the injuries that happened to the plaintiff would have happened regardless of his actions in surgery. Dr. Ward, on the other hand, never made those claims. Of course, since the doctor in this surgery made this claim, the plaintiffs had the burden to disprove non-negligence. At trial,
Counsel, I'm sorry to interrupt, but I'm still struggling with your treatment of essentially the zero risk theory. So the majority of the Court of Appeal found that theory just wasn't supported by the literature in this case, and there could be accidental but non-negligent events here, such as surgical dexterity or a structure unexpectedly moving during the procedure. How do you respond to those issues raised by the Court of Appeal?
Thank you for your question, Justice. So I'm actually getting there in my submission right now. So as for these new non-negligent causes suggested by the majority at trial, such as, like you said, structures unexpectedly moving during surgery, I would remind this court that none of these potential non-negligent causes were mentioned at trial, only on appeal. There is no evidence to support that that was a thing that could have happened. And the zero risk theory is the theory that was brought forth by Dr. Bernstein, expert for the plaintiff. And the trial judge actually didn't accept his theory because he just thought it would amount to a standard of perfection. It would be too too extreme to accept a zero risk theory, obviously. So what it is there's a less than 1% chance that in this type of surgery, you would actually come in close contact with the ureter. And that is in cases where the colon or the ureter of the patient is not anatomically normal. So let's say it's inflamed or there's something wrong with it and that's why they're going through with the colectomy. In those cases, it's still a less than 1% chance. So that's why the expert witness was testifying, if it's a normal colon, normal ureter, it should be 0. It should be less than the 1% that it is when it's not swollen. I hope that answers your question, Justice. Thank you. So at trial, the defendant's expert witnesses submitted 2 possible non-negligent theories as to how this type of injury could have occurred. They were both rejected at trial because the literature just simply did not support them. There was no case available to demonstrate that this ever actually happened or could happen. And as said by Dr. Colts, the ligature is a device that is used all over the world and has an excellent safety record. Since these non-negligent theories were unsupported by the evidence and rejected by the trial judge, the plaintiffs need not take on the burden. It's already been taken care of. This honorable court held in Danny Look versus Ainsworth Technologies that litigants are only entitled to 1 bite at the cherry and are required to put their best foot forward to establish the truth of their allegations when first called upon to do so. The trial judge rightfully assumed both parties had put their best case forward at trial and rightfully decided based on the evidence before him. The plaintiff certainly cannot be expected to disprove all non-negligent causes, especially ones that were only brought up on appeal and not at trial. To conclude my submissions, we respectfully submit that this court should set aside the judgment of the Court of Appeal and restore the trial judgment. The trial judge appropriately established standard of care and rejected non-negligence based on the evidence and lack thereof before him. The trial judge did not use a goal-oriented approach to define standard of care. It was well recognized throughout the trial that staying away from the ureter was a step a surgeon must take when conducting a laparoscopic colectomy, not a goal. Finally, the plaintiff should not have the duty to rule out all non-negligent causes, specifically those not supported by the evidence and those not brought forth at trial. Subject to any further questions, that does conclude my submissions.
I'll give my colleagues a chance to ask a question before I ask a follow-up. So are you suggesting then, counsel, that absent some kind of anatomical problem like inflammation, any injury means there is negligence? Is that what you're asking this court to find? Because that does sound like a strict liability argument to me.
Respectfully, Justice, no, that is absolutely not what we're submitting. We're submitting specifically in regards to the ureter, just because this structure it's so easily avoidable in these surgeries. The risk level is so low, and even in cases where it should be a lot higher risk, and it's the same when it's not done laparoscopically. When it's done like open, it's still the same amount of risk, the less than 1%. So in a case where everything is, structurally normal, it should be close to 0. And the thing in this case was Dr. Ward, he would not admit that he actually did damage the ureter. He always maintained that he stayed 5 centimeters away at all times. And in this case, we're kind of proving that obviously couldn't have happened based on the circumstantial evidence provided. So yes, we would just submit that based on the steps required to take the standard of care, he did not stay outside of the ureter in the proximity he was allowed.
I'm just going to ask a quick question, counsel. So if in that instance, then are you not sort of relying on the damage itself to prove, to say whether or not the standard of care was breached? And don't you think that you are then, of course, confusing causation and standard of care?
Thank you for that question, Justice. This is kind of more going into my co-counsel submissions, but I'll touch on it briefly. So the court obviously, as established in Fontaine, does have that right to, evaluate both the direct and circumstantial evidence before them. And the plaintiff obviously needs to submit their evidence establishing negligence. The defendant must then reply and say, this is my evidence that negates their evidence. And then based on that, the trial judge has every authority to, look at the circumstantial evidence, weigh the defendant's evidence, and then make his decision based on who he accepts. It's not really an issue of conflating causation and standard of care, as my co-counsel will better explain in more detail.
Do we have time for one follow-up to Justice Crane's question? Yeah, okay, thank you. So I have a question for you, following up on Justice Crane's question about concluding from the fact of an injury that there was carelessness or negligence. And you seemed in your response to her to be saying that where a particular outcome or injury was extremely unlikely, then one could conclude that it could only have come about in a negligent manner. And I'm wondering, you cited 1%. What would you say is the specific degree of unlikeliness where we can essentially conclude negligence from the fact of the injury? Is it 0.5%? Is it 0.25?
Thank you for this question. So I'm pretty sure the number was 0.33 to 0.66 was when there was an anatomic issue such as swelling, which is why I'm suggesting that it would be much lower. So maybe, I don't know, 0.1 potentially. But this is why it was suggested that it was a 0% risk. I think the main issue in this case is that Dr. Ward could not present a time where this would have happened in a non-negligent manner. So it's not really about percentages. It's just, show us that you could have done this non-negligently. And obviously he couldn't do that. He submitted that he was 5 centimeters away, and from the 5 centimeters away caused a burn that started along the ureter and produced scarring. And based on that testimony, there's no supporting evidence in the medical literature. And like I said earlier, this device has been used all over the world, has an excellent safety record. Surely we would have seen if this could ever possibly happen, a burn from 5 centimeters away. And I think it's just the fact that there was no evidence to support that we can't accept that it could have happened in that way.
Thank you.
Thank you. Thank you, Justices, for hearing my submissions today. That does conclude my submissions, and I'll now pass the floor to my co-counsel.
Good morning, Justices. My name is Tony Pascale, and I will be dealing with the second 2 issues on causation and standard of review. I have 2 points on my submission. First, the trial judge did not err in using circumstantial evidence to inform the standard of care. And second, the majority erred in applying a correctness standard of review rather than a reasonable standard of review. My first point follows that causation can be considered as circumstantial evidence to inform the standard of care. My friend's concerns surround the fact that the trial judge analyzed the cause of Miss Armstrong's injuries before concluding that Dr. Ward breached the standard of care. The trial judge is to determine whether there was a breach of the standard of care before addressing causation. However, in some instances, determining what happened and how it happened could be relevant circumstantial evidence and help to determine if there was a breach in the standard of care. They had to analyze what happened to figure out if Dr. Ward did the thing he said he did not do, come within 2 millimeters of the ureter, and they had to do so on a balance of probabilities. In Kennedy versus Jackowitz, the court held that it is nonetheless open to experts and to the court to draw inferences of fact. It may be appropriate then for an expert of the court to infer from the nature of the injury what it was the surgeon did. There were two possible explanations of how Miss Armstrong's injury occurred that the trial judge assessed. The first was that Dr. Ward breached the standard of care and brought the ligature within 2 millimeters of the ureter. And the second was that he remained a safe distance. However, scarring occurred and traveled through the abdomen and caused damage to the ureter. These causes imply a very different explanation of Dr. Ward's actions during surgery. Considering these potential causes, the trial judge had to rely on the outcome of the case, looking at the nature of the injury to determine whether Dr. Ward met the standard of care. Without looking at the injury sustained, it would not have been possible for the trial judge to determine if negligence was a matter of fact in this case. These potential explanations are simply theories that are not found within academic literature. With respect, the court's role is not to hypothesize about explanations not found within evidence. They must consider the evidence on a balance of probabilities, which is what the trial judge did. Considering the lack of firsthand evidence from expert witnesses brought forward by my friends, the more probable explanation is that Dr. Ward came within 1 to 2 millimeters with the ligature. The majority held that this would be an appropriate analysis of the standard of care, in this case, as the thermal energy was circumstantial evidence of what happened. However, the majority held that the trial judge erred in considering the standard of care, leading them to state that considering causation would not have been an independent error in analyzing this case. In other words, the majority did not find issue with the fact that the trial judge considered causation in determining if standard of care was breached. In their factum, my friends also write that using causation to define the standard of care risks creating a standard of perfection. First, the trial judge did not use causation to define the standard of care. This is not what we are arguing. The trial judge used it to inform the standard of care. The trial judge did not impose a standard of perfection. He found that although Dr. Ward maintained following the steps required to meet the standard of care, he had not met the final step required, staying 2 millimeters away from the ureter, which is proven by this injury. The trial judge heard expert testimony from 5 doctors, including Dr. Ward himself, all who agreed that the standard of care is to identify and protect the ureter, and the way in which you protect the ureter is by staying 1 to 2 millimeters away from it during surgery. This finding was supported wholly by evidence provided at trial. Staying 2 millimeters away from the ureter was not a goal of the surgery, but an essential step. Using circumstantial evidence disproves the fact that the trial judge expected perfection. In fact, as my co-counsel mentioned, the trial judge rejected the statement that there should be 0% chance of injuring the ureter if following these steps because he did not want to impose this standard of perfection. My friends write that the trier of fact must consider whether what was done breaches the standard of care, not use the evidence of what happened as the standard of care. Respectfully, the trial judge does not do this. The trial judge simply expected Dr. Ward to protect the ureter by remaining 1 to 2 millimeters from it, and based on the evidence at hand, he did not. Given the competing theories proposed at trial, the trial judge could not have determined what Dr. Ward did without first considering how the injury occurred. Moving to my second point, standard of review is a question of law reviewed for correctness, and the court must consider mixed fact and law to review for errors that are palpable or overriding. The majority erred in applying a correctness standard of review and should have instead applied a reasonable standard when considering the trial judge's findings. It is important to note that a court of appeal must have substantial reasons for overturning a trial decision and must take more than different views of evidence into account, which they do not. In their factum, my friends quote Hussein versus Nicolason in stating that what appears to be a question of mixed fact and law can simply be an error of pure law, which requires a standard of correctness. The issues that the Court of Appeal had with the trial judge's decision is not an issue of pure law, it was an issue of semantics. The majority in Hussein states that the appellate courts must be cautious in finding that a trial judge erred in law in their determination of negligence, and it is often difficult to extricate the legal questions from the factual. Where the issue on appeal involves the trial judge's interpretation of the evidence as a whole, it should not be overturned absent palpable and overriding error. The majority determines that had the trial judge worded the standard of care differently, not changed the meaning, but changed the wording, the submissions would have been accepted by the Court of Appeal without dispute. This is not a palpable or overriding error. This is merely an issue of misunderstanding. In Cooper versus Floyd, the Court of Appeal and trial judge differ in their holding of the case because they interpret the evidence differently from each other. The court held that it is reasonable for the Court of Appeal to review, re-examine, and reweigh evidence provided. They must also come to a reasonable conclusion, in which case the trial judge's finding in Cooper was not unreasonable. Like this case, the majority erred in not accepting the trial judge's explanation of the standard of care as a goal. Overturning the trial judge's holding should not occur in absence of palpable and overriding error. In Hassan versus Anvari, Dr. Anvari submits 2 non-negligent explanations for the patient's injury sustained during surgery, and the Court of Appeal rejected the argument made and determined that the trial judge was entitled to reject these options based on evidence. The court in Hassan rejected these options and considered them to be speculation, which lacked evidence, similar to Justice Van Rensburg's dissent in stating that there was no evidence to support Dr. Ward's non-negligence option. Having differing opinions surrounding conclusions of cases is anticipated. However, the finding of facts will remain the same. In Benaim versus Saint Germain, the court holds that the trial judges are immersed in evidence. They hear viva voce testimony, and they are familiar with the case as a whole. Their expertise in weighing large quantities of evidence and making factual findings ought to be respected. The trial judge's position is to hear these testimonies in court and determine if they are of value to the case. In a medical negligence case, medical expertise is crucial to coming to a result, and considering the expert witness preference of the trial judge is imperative. The trial judge had evidence to support their holding. However, the majority did not respect these findings, which usurps the trial judge's role within the court system. As the dissent states, deference is owed to the trial judge on all findings other than on questions of pure law. The trial judge did not err in the definition of the standard of care, as my friends suggest. Rather, the majority disagreed with the phrasing of the standard of care. This is not reason enough to overturn the trial judge's findings, nor is it reason to reweigh evidence presented before the trial judge. Semantics does not constitute as palpable or overriding error, and therefore the majority erred in their application of standard of review, and the court should overturn this decision to reflect that of the trial judge. To conclude my submissions, we respectfully submit that this court should set aside the judgment of the Court of Appeal and restore the trial judgment. The trial judge appropriately considered circumstantial evidence in informing the standard of care and in determining how Ms. Armstrong's injury occurred. The majority at the Court of Appeal erred in applying a correctness standard of review, as disagreement surrounding semantics does not constitute as overriding or palpable errors. Subject to any further questions, that concludes my submissions.
Thank you, Counsel. I have a question I'd like to put to you, and that is, it's the burden on the plaintiff, on your client, in this case, to establish all elements of the cause of action, of the negligence cause of action. And isn't there a serious risk if a conclusion is drawn on causation before standard that there will be a bias in assessing standard? So having determined that a burn in fact occurred, did that not pollute the finding then of whether that actually met the standard of care? That it is, after all, your client's obligation to establish that in fact this burn did come about in a careless way, having accepted that the burn did cause the injury.
Thank you for your question, Justice. Sorry, can you repeat the question?
Sure. Is there not a risk of a bias in concluding, using the fact of the cause of a burn being the ligature, that this will then foreclose the proper analysis of the standard of care? It's your client's duty to, or burden to, establish that this burn came about in a careless manner. And the evidence of Dr. Ward was that he stayed 5 centimeters away. It was, after all, your client's obligation to establish that the burn was carelessly inflicted.
Yes, thank you. So the trial judge heard the expert testimonies, including from Dr. Ward himself, and they all said that identifying and protecting the ureter were steps of the surgery. So the trial judge used that as the standard of care. They decided that identifying and protecting the ureter was the main goal of the surgery. Not the main goal, sorry. Removing the colon was the main goal, but it was a step in the surgery. And when the trial judge was trying to see how this injury occurred, Dr. Ward did say that he remained 5 centimeters away. However, as my co-counsel mentioned, there was no academic literature to support the fact that if he had stayed 5 centimeters away, this injury would have occurred. All of the expert witnesses, not the ones presented by the defendants, they submitted that this injury could have occurred by staying 5 centimeters away through an injury in the abdomen causing scar tissue. But they had all submitted that they had never firsthand seen that, nor was it submitted by academic literature. So the trial judge had to look at how this issue could have come about in actual academic literature to discover if Dr. Ward breached the standard of care. I hope that answered the question. Yes.
If I may, aren't you essentially still trying to apply a standard of perfection on the doctor? So as we've already heard, the probability of any of these injuries occurring is 1% or less. So by expecting medical literature to support every aspect of competing theories of how the damage may have occurred, isn't that still, given that the probability of the injury happening is so low, aren't you still essentially applying a standard of perfection given how rare this injury actually is?
No. So obviously mistakes happen we're not suggesting that if something had happened during the surgery that, as my co-counsel suggested, if there was an earthquake, they would have to suggest, okay, there was an earthquake, this happened. Obviously, that's not a standard of perfection because we wouldn't be able to say that the doctor was negligent if it was matters beyond their own control. But in this case, identifying and protecting the ureter were two important steps that the doctor had to take to ensure that they did not damage the ureter. So in not taking those steps properly, he was negligent. And they did suggest that there was that non-negligent option that was brought up at the Court of Appeal, not at trial. And sorry, no, it was brought up at trial. They suggested those non-negligent options, but when there's no academic literature to support those options, and it's a medical negligence case, how is the trial judge supposed to infer that, okay, there's been no proof and there's no academic literature, but maybe this could have happened? The court can't use hypotheticals and try to make sense of issues using hypotheticals. The court has to look at it and reasonably look and say, okay, if the main way that this could happen and the way that this could happen is supported by medical academic literature, then this must have been what happened. And yes, that concludes my submissions. Thank you.
The court now invites counsel for the respondent to begin.
Good morning, justices of the panel. My name is Samantha Iantomasi, and together with my colleague, Mr. Ovas, we will be representing the respondent, Dr. Ward. We have split our submissions today. My submission will focus on the proper standard of care. My colleague will focus his submission on causation used as circumstantial evidence, the plaintiff ruling out non-negligent causes, and the appropriate standard of review. I submit that the trial judge erred by imposing an improper standard of care, which is an error of law. I will argue in 3 parts. First, the proper standard of care is based on steps, not goals. Second, the standard of care cannot be a standard of perfection. And third, the Court of Appeal was correct to find that Dr. Ward did not breach the standard of care. To begin, I would like to recognize that this case involves a tragic accident. Unfortunately, accidents happen. However, the fact that an injury occurred does not mean there has been negligence. This surgery was not risk-free. Dr. Ward acted in a manner that is consistent with a reasonably prudent surgeon. Given that the standard of care for medical negligence is reasonableness, not perfection, the Court of Appeal was correct to find that Dr. Ward did not breach the standard of care. In my first submission, I will focus on how the proper standard of care is based on steps, not goals. The trial judge's standard of care was improper because it focused on the goal the surgeon intends to achieve, not the step the surgeon takes. The appellant submits that a goal versus a step is a matter of semantics. Respectfully, I disagree. Staying 1 to 2 millimeters away from the ureter is a goal, because as stated by Dr. Bernstein, the goal of the surgery was to remove the colon without injuring any other structures, including the ureter. Bringing the ligature within 2 millimeters of the ureter is the injury because it results in thermal energy damaging the ureter. The appellant uses the example of getting an A on the final exam. They said that if the goal was to get an A, the steps would include studying, and completing an exam review while studying counts as a goal. I respectfully disagree. Completing exam reviews would not be a goal, but rather it would be a step taken towards getting an A. Steps are actions that are taken within a person's control. Completing an exam review and studying are both steps because it's an action taken that's within the person's control. In contrast, getting an A is a goal because it's something a person hopes to achieve, but it's not fully within their control. I'm sure everyone has taken an exam that they planned on doing well, but when they got their mark back, it wasn't what they were hoping for. You could have taken all of the steps to get an A, such as studying and completing exam reviews, but you might not get an A. Steps and goals must not be confused when framing the standard of care. You can't interchange steps and goals. They must remain distinct in order to ensure that the standard of care is not a standard of perfection. All of the experts agreed, and the trial judge accepted as evidence, that the steps taken to avoid injury are: number 1, identify the ureter through remiculation; number 2, move the ureter away from the colon; number 3, recheck the location of the ureter; and number 4, try to avoid bringing the ligature within an unsafe proximity. Only when all of these steps are taken can the surgeon meet the goal of removing the colon without causing injury. As stated by Justice Pachaco, trying to maintain a safe distance is a step one takes. Successfully achieving this is the goal. Therefore, staying 2 millimeters away from the ureter is the goal, not a step. The Supreme Court in Feloka found that it was an error to impose an absolute duty rather than a duty of reasonable care. The trial judge based the standard of care on the outcome rather than the steps needed to take to avoid the outcome. In Feloka, miners were killed after a striker trespassed into the mine and caused an explosion. Pinkerton's was hired as security at the mine. The trial judge found that Pinkerton's breached the standard of care because it failed to stop people from entering the mine. The Supreme Court overturned the trial judge's decision because it created an absolute duty and it didn't explain what steps Pinkerton's needed to take to stop people from getting into the mine. In the present case, the trial judge failed to base the standard of care on the steps Dr. Ward needed to take to avoid bringing the ligature within 1 to 2 millimeters of the ureter. The trial judge imposed an absolute duty on Dr. Ward by defining the standard of care based on the outcome of the surgery. Following the Supreme Court's reasoning in Feloka, this was an error. In St. John, the Supreme Court found that basing the standard of care on the goal is incorrect because it focuses on the result rather than the means taken to achieve the result. The court in St. John states that professionals have an obligation of means, not an obligation of result. This shows that doctors are required to take all reasonable steps, but they are not required to achieve a perfect outcome every time. The Court of Appeal correctly held that the proper standard of care is measured by the steps a prudent surgeon would take. Applying this principle of medical negligence to the facts, Justice Pachaco stated that prudent surgeons would take the step of not knowingly, intentionally, and unnecessarily deploying the ligature within 2 millimeters of the ureter. Second, the standard of care cannot be a standard of perfection. Using a goal as a standard imposes a standard of perfection because it creates an absolute duty. This means that when the standard of care is based on avoiding injury, which is the goal of the surgery, any injury results in liability, even if the surgeon takes the proper steps to avoid the injury. The trial judge held Dr. Ward to a standard of perfection because the standard was based on not injuring the ureter, which is the goal of the surgery. Dr. Ward cannot be held to a standard of perfection because this procedure has a risk of ureteric injury. The appellants submit that because Ms. Armstrong had an ideal setting for the procedure, the risk of injury should be even less than the risk the trial judge accepted. This is not true. Pre-existing conditions such as a tumor or inflammation would have presented an increased risk. The trial judge found that the risk of injury for Ms. Armstrong's procedure was less than 1%. If Ms. Armstrong had pre-existing conditions, the risk of injury would have been greater than 1%. The trial judge rejected Dr. Bernstein's theory that the risk of injury should be 0 because it's not supported by the literature. As stated by the court in Campbell and Fairley, the fact of low incidence of injury, together with the fact that injury occurred, does not create a finding of negligence. Dr. Ward cannot be held to a standard of perfection for this surgery because it has a risk of injury to the ureter. Dr. Ward warns his patients about this risk prior to surgery. When Ms. Armstrong consented to the surgery, she was consenting to the risks as well. The appellants argue that the injury to the ureter could have been easily avoided. Respectfully, this is untrue. This surgery is complex and it involves close proximity with many structures in the abdominal cavity. It's unfair to say that a surgeon will not injure the ureter because the ureter can be easily avoided. This procedure has a risk of injury to the ureter, therefore it's requiring perfection for the surgeon not to injure the ureter. In Carlson and Sutherland, the BC Court of Appeal found that the trial judge erred by imposing a standard of excellence. The trial judge inferred that the surgeon was negligent from the fact that injury occurred. The Court of Appeal stated that the trial judge imposed a standard of excellence that was impossible to rebut and resulted in an absolute duty. The trial judge erred by focusing on the result of the surgery instead of the steps the surgeon took. We recognize that patients place a great deal of trust in their doctors. However, doctors are not superhuman. They can't avoid injury in every surgery, especially when there's a risk of injury. A standard of perfection places an impossible burden on doctors. In order to achieve a decision that does justice to both parties, courts must judge doctors based on the reasonable steps they took. This was done by the Court of Appeal. Third, the Court of Appeal was correctly found that Dr. Ward did not breach the standard of care. The trial judge found that Dr. Ward took all of the appropriate steps to identify and protect the ureter. In other words, the trial judge found that Dr. Ward behaved as a reasonably prudent surgeon when performing this procedure. The Court of Appeal found that this shows Dr. Ward did not breach the standard of care. It cannot be said that Dr. Ward acted negligently when he performed this surgery cautiously and appropriately. The trial judge did not find that the only way the ligature could have come within 2 millimeters is by negligence. The appellants argue that the majority decision sets a dangerous precedent that requires doctors to try their best in order to meet the standard of care. I would respectfully disagree. This confuses the standard of care the majority applied. The majority did not find that Dr. Ward tried his best. They found that Dr. Ward successfully performed the surgery as any reasonably prudent surgeon would have. Based on the trial judge's findings that Dr. Ward took the appropriate steps to identify and protect the ureter, the majority concluded that Dr. Ward did not breach the standard of care. The appellants also argue that there is a difference between using an appropriate technique and performing said technique properly. I respectfully submit that Dr. Ward did perform the technique properly during this procedure. Dr. Ward took all of the proper steps when performing the surgery. It can be said that he did not perform the technique properly because he came within 2 millimeters of the ureter. This surgery has a risk of injury, therefore the surgeon can perform the technique properly and still end up with an injury. We submit that the ligature did not come within 2 millimeters of the ureter because of negligence. Dr. Ward took all of the appropriate steps and he did not breach the standard of care. Justices, those are my submissions, subject to any questions. Thank you.
Counsel, I have a question. The Court of Appeal, as I read the decision here, does say that in some cases the outcome alone could be enough to make a finding of negligence, and they give 2 examples: wrong-limbed surgery or leaving a retained tool or sponge. How do you say that this case is different from those cases? In those cases, the fact of negligence was obvious.
It's obvious that a surgeon is negligent if they leave a tool inside the patient's body. However, in this case, it wasn't obvious that Dr. Ward was negligent. He took all of the proper steps in order to identify and protect the ureter. And based on that, the Court of Appeal found that he was not negligent.
Counsel, a question for you. It's the obligation of the plaintiff to propose an account of what happened and enough evidence that permits a judge to accept that on the balance of probabilities, that is what happened, that there was carelessness, that carelessness caused the injury. Now, in a case like this, the appellant has provided an account and a proposal and a burn that could only have come from the ligature. And surely the trial judge, or I should say the judge, is entitled to conclude that there was causation and that this could only have been done negligently. It would be up to the defendant to provide some contrary evidence to displace that conclusion. If the plaintiff had succeeded in getting past the balance of probabilities standard. And in this case, isn't your client best placed to provide some sort of explanation for how the ligature could have come close to the ureter, even if all appropriate care had taken? So the fact that none was provided, is that not evidence that ought to be taken into account here?
Yes, in my submission, it is the duty of the plaintiff to raise potential causes of non-negligent injury. So Dr. Ward said that he did not come within 2 millimeters of the ureter. However, the trial judge did find, as a matter of fact, that he did come within 2 millimeters and that was how the injury occurred. We do not disagree with this finding of fact. However, it's our position that because Dr. Ward had taken all of the appropriate steps, that he was not negligent because he could not have reached the standard of care by taking these steps. And it's up to the plaintiff. When the plaintiff relies solely on negligence as the cause of injury, the plaintiff must raise all potential other non-negligent causes. And the trial judge did not rule out other non-negligent causes and reasons for why the ligature could have come within 2 millimeters. And in my submission, this was an error for the trial judge to do so. Thank you, Justices. I'm going to turn it over to my colleague, Mr. Ovas, now.
Good morning, Justices of the panel. My name is Sean Ovas, and I am also here with my partner in representation of the respondent, Dr. Ward. My submissions will also be split into 3 parts and will focus on causation and the applicable standard of review for this matter. Firstly, I will argue that causation can only be used as circumstantial evidence to inform the standard of care, but not to define it. Secondly, in order to establish causation, the plaintiff does have a duty to disprove non-negligent causes of the injury. And finally, the standard of review for this matter is only correctness, and the majority did not fail to give deference to the trial judge's findings of fact. So my first submission is that causation can be used to inform the standard of care, but it cannot be used to define it. In this case, causation did not need to be used to inform the standard of care. The plaintiff's injury was not relevant to the applicable standard Dr. Ward owed to the patient. The trial judge found that Dr. Ward took the appropriate steps agreed upon by expert testimony to identify and protect the ureter. The trial judge should have based the standard of care on these steps and come to a conclusion that Dr. Ward met the standard of care based on this before addressing causation. The majority agreed in their decision that had the trial judge properly defined the standard of care, causation would not have needed to be addressed. The appellants argue that in some instances, causation can be used as relevant circumstantial evidence to determine if there was a breach in the standard of care. We respectfully agree. However, we are also in agreement with the majority in this case, who held that causation cannot be used as circumstantial evidence to define the standard of care. This is consistent with the trial judge in Kennedy v. Jakiewicz, who noted that a trier of fact must consider whether what was done breaches the standard of care, not use the evidence or injury as the standard of care. And this is the error that the trial judge made in this case. The trial judge concluded that the standard of care would be breached by touching or coming within 1 to 2 millimeters of the ureter based on the evidence that the injury occurred this way. The trial judge then concluded that Dr. Ward breached the standard of care after determining how the injury occurred. As the majority held, the standard of care should have been defined using the agreed upon steps that Dr. Ward took during the procedure. Using causation to define the standard of care risks creating a standard of perfection, which creates an absolute duty, placing an impossible burden on doctors to avoid all injuries. The appellant's position is that the trial judge had to rely on the outcome of the case and the nature of the injury to determine whether Dr. Ward met the standard of care. However, as my colleague correctly argued, it was incorrect to include this circumstantial evidence as the standard of care, as it is based on a goal. In Locke v. Smith, the Ontario Court of Appeal found that the trial judge did not err by failing to determine the cause of the plaintiff's perforated bowel. The trial judge did not have to determine causation because he had already determined that Dr. Smith had met the standard of care. The court concluded that determining causation would have not changed the finding that Dr. Smith was not negligent. Similarly, in this case, the Court of Appeal concluded that if the trial judge imposed the proper standard of care, he would not have needed to consider Ms. Armstrong's injury. Even if such circumstantial evidence had been considered, it would have not changed this finding, as the correct standard of care should have been based on the steps that would be taken by reasonable surgeons performing the same procedure. The trial judge determined the steps that Dr. Ward took without first considering the circumstantial evidence regarding the injury and should have assessed whether there was a breach of standard of care by comparing these steps to Dr. Ward's actions. Our second submission is that in order to establish causation on a but-for standard,
Counsel, I'm sorry to interrupt you, but before we move on from that, I'm interested in how you deal with Justice Van Rensburg's treatment of this in the dissent. As I understand the dissent, he's drawing a distinction between factual causation and legal causation, and he says the trial judge did nothing but make a finding on factual causation, and so therefore there was no error. How do you respond to that?
Our position is that the injury wasn't needed to be considered in this case in alignment with the majority of the Court of Appeal. Causation, or the reasonable legal causation, and the most important thing to consider was the reasonable steps that the experts agreed should have been taken. So the trial judge considered the steps based on expert testimony and then agreed that Dr. Ward took those steps. And that is our position, is that the majority should have based, or that the trial judge should have based the standard of care on those steps. The extra steps of considering the nature of the injury and factual causation were not necessary in this case. They can be used to inform the standard of care in some cases, but we agree with the majority that it wasn't necessary in this case, as Dr. Ward had already followed the agreed upon steps that were presented by expert testimony to protect and identify the ureter. And this was accepted by the trial judge that Dr. Ward took these steps. I hope that answers your question. Our second submission is that in order to establish causation on a but-for standard, the plaintiff is required to disprove potential non-negligent causes. Though causation is not relevant to the majority's decision to allow Dr. Ward's appeal in this case, had the analysis proceeded to the stage, the plaintiff has the duty to disprove potential non-negligent causes in order to establish causation. The majority held that when negligence is relied upon by the plaintiff as the only cause of injury, the trial judge has a duty to consider and rule out other non-negligent causes of injury before finding liability. This is consistent with the procedure of other medical negligence cases. In Cooper v. Floyd, the plaintiff suffered a perforated bowel after a surgical procedure was negligently performed by the defendants. On appeal, the majority held that the trial judge correctly found the defendants liable after reasonably dismissing other possible non-negligent causes for the injury, including the plaintiff's past surgeries and the type of procedure applied. In consistency with Cooper, it falls upon the trial judge to reasonably dismiss such non-negligent causes before finding liability, and this should have happened in the current case. In such cases where negligence is relied upon as the only cause, it is necessary for the plaintiff to disprove such causes in order to be fair to the defendant. We agree with the appellants that the plaintiff is often unconscious and lacks knowledge of the complex medical procedures that doctors are performing. However, this does not mean that plaintiffs should be excused from ruling out potential non-negligent causes. It is always open for plaintiffs to raise expert evidence to show whether or not the defendant was negligent. The appellants further argue that a plaintiff should not be required to bring forth evidence that the defendants do not raise. This is not the respondent's position in this matter either. Our position is that the plaintiff is required to disprove all non-negligent causes raised that are supported by sufficient evidence. As the Supreme Court noted in Edinger v. Johnston, defendants are free to provide evidence contrary to the plaintiff's causation theory, to persuade a trial judge that the plaintiff has failed to meet their burden. In contrast, the appellants argue that if the defendant fails to raise evidence to support potential non-negligent causes, the plaintiffs are not responsible for addressing them, and the trial judge is not obliged to consider them. I respectfully disagree. Plaintiffs have the duty to rule out potential non-negligent causes. The Court of Appeal correctly found that the trial judge failed to rule out potential non-negligent reasons for why the ligature could have been brought within 2 millimeters of the ureter. Dr. Bernstein, the expert from Miss Armstrong, posited that the risk of injury from using a ligature should be 0. However, the trial judge rejected this view and instead adopted a view that the risk was less than 1%. As the Court of Appeal noted in their decision, there was no evidence that Miss Armstrong's injury could only be caused by negligence. This left open the possibility that other causes could have potentially resulted in this injury. In order to make the trial fair, the burden was on the plaintiff to rule out potential non-negligent causes. Our final submission today is that the majority correctly applied a standard of correctness on appeal and did not fail to give deference to the trial judge's findings of fact. The main issue on appeal in this case is whether the correct standard of care was applied by the trial judge, which the Supreme Court has held is a question of mixed fact and law. The appellants assert that when addressing questions of mixed fact and law, the required standard is one of a palpable or overriding error. This is not always true. In the leading case on appellate review, Houston v. Nicolason, the Supreme Court held that what appears to be a question of mixed fact and law can simply be an error of pure law. This only requires a standard of correctness. In consistency with Houston, the Ontario Court of Appeal held in FC v. Ontario Inc. that if challenged findings rely on an incorrect statement of the applicable standard of care, the less deferential standing of correctness is required. Similarly, in Ontario Inc. v. Maple Leaf Foods, the correct standard of review for whether a defendant or whether an appellant owed a duty of care is a question of law requiring correctness. Both the standard of care and duty of care are paramount to negligence claims and must be considered on the same standard. The appellant's position is that the majority overturned the decision of the trial judge because he did not express the standard of care to their liking. The appellants base this position on a view that the majority should have accepted that coming within 2 millimeters of the ureter is part of the standard of care. I respectfully disagree. As argued by my colleague, basing the standard of care on the injury, coming within 2 millimeters, is a goal-based standard and is incorrect. This is not a dispute over the outcome of the case, but over whether the correct reasonable standard of care was applied to Dr. Ward. This is only a pure question of law and not fact. The appellants also argue that the majority did not respect the trial judge's findings or preference for the plaintiff's expert testimony. However, the majority did not dispute any findings of fact or inference of fact made by the trial judge. They only focused their analysis on whether the correct standard of care had been applied. The majority's holding was that the trial judge should have determined that the standard of care should be informed by the agreed upon steps a reasonable surgeon would take, not the goal of staying 1 to 2 millimeters away from the ureter. This is an error of law, attracting only a standard of correctness and nothing further. And that concludes my submissions today, Justice of the panel, absent any questions. And we finished today with a request that this appeal be dismissed as the majority made no errors in the review of the trial judge's findings. And I'm able to answer any questions at this time.
Counsel, was it not open to the trial judge to reject Dr. Ward's suggestion that he had properly followed these steps, that in fact he'd kept the ureter in view at all times? That seems to me that rejecting your client's evidence and imagining that in fact there was a time when there was an injury caused and this was done through carelessness was within the trial judge's purview.
Yes, thank you. We are not disagreeing with the inference that was made by the trial judge. Our position is that the injury was not needed to be considered in this case, and we're in agreement with the majority on that position. The trial judge is free to consider the nature of the injury and that circumstantial evidence to inform the standard of care, but our position is that the standard of care should have been based on the reasonable steps that were taken prior to the injury itself. The trial judge accepted that Dr. Ward took the 4 identified steps provided by the experts, and that is what they believe that the standard of care should have been. And it was their position that the injury itself was not needed to be considered in this case.
But isn't it a little bit artificial to itemize a list of steps that need to be taken and check them off if done? The important thing is whether those steps were done carefully enough, up to the requisite standard. So just sort of noting that in fact the steps were done does not satisfy the obligation to do them at the requisite standard of care.
As we know Dr. Ward was very careful. He did take all of the 4 identified steps that were listed. We know that he had the ligature or the ureter in view of the camera when it was most at risk, and he was confident that he kept away from that. And we're going back to the majority's review. We know that he took the identified steps prior to the injury itself, but as the majority noted, the trial judge addressed the standard of care after the injury occurred, but did not consider steps that should have been taken to prevent the injury. They rested after he considered the injury. He accepted that there was a breach. He didn't note any steps that needed to be taken. Instead, he based it on a goal and didn't address the steps that would be needed to prevent that goal or to protect the ureter.
Do you think it's reasonable to put the burden on a plaintiff in a case like this to disprove all non-negligent explanations? After all, if one of the non-negligent explanations is, well, this slipped and sometimes devices slip, how is the plaintiff in a position to disprove that that were the case? These are facts that are wholly within the knowledge of your client.
Yes. Our position is that this is necessary when the plaintiff is relying on negligence as the only cause. And as I noted in my submissions, the plaintiff is able to bring in expert testimony to identify and rule out potential non-negligent causes that have been raised that are supported by the evidence. So they have the expert testimony available. And that's similar to what happened in the cases that I referenced in Ediger and in Cooper. The potential non-negligent causes were disproven by the trial judge. So assistance of expert testimony.
Thank you.
Thank you. If there are no further questions, I thank the court and the justices for their time and request that this, again, request for a dismissal of this appeal. Thank you.
The court now invites counsel for the appellant to begin their optional 3-minute rebuttal.
Thank you, justices. So first, I would like to point out that if the Court of Appeal decision is upheld, I would like the court to imagine what a dangerous precedent this would set. Doctors arguing that they tried their best to avoid damage would be good enough to deem them non-negligent. Plaintiffs are already at a disadvantage in medical malpractice cases as it is. Imagine how hard it would be for them to prove negligence after such a holding. Second, I would like to reiterate the submissions of myself and my co-counsel when I say that the trial judge was not imposing a standard of perfection. We acknowledge the risk was low, very low, but yes, low risk does not mean no risk. But when the defendant cannot show the court a non-negligent reason that aligns with the damage and that is supported by evidence, how could the trial judge possibly accept such an argument? Our friends submit that it would be unjust to hold Dr. Ward to a standard of perfection in not damaging the ureter. Let me remind you the evidence of Dr. Ward's own expert witnesses. Dr. Hagen is a surgeon called by the defendant where he reiterated that the standard of care was to identify and protect the ureter, which he claimed would ensure that the ligature does not come within 2 millimeters of the ureter. He said, if the steps were taken properly, you will not come within 2 millimeters. Dr. Robinette is a urologist who testified on behalf of Dr. Ward, stating that the standard of care required Dr. Ward to find the ureter and to stay far away from it, not to damage it. Additionally, what the court had to say in regards to circumstantial evidence in Fontaine is that the plaintiff obviously does have the burden to prove negligence. They must bring forward proof. The defendant must then present their evidence negating the plaintiff's evidence. Then, based on available direct evidence and circumstantial evidence, the trial judge has the discretion to decide whether the defendant evidence actually does negate the plaintiff's. Simply put, in the case at bar, the trial judge did not find that it did, and he had every authority to make such a finding. Finally, with respect to semantics, steps, goals, outcomes aside, no one ever submitted that not damaging the ureter was the outcome of a laparoscopic colectomy. Of course it wasn't the outcome. The outcome was to remove the colon. Protecting the ureter is a step in this process. If this was a pure question of law, not fact, as our friends submit, a new trial should have been ordered. The trial judge's finding should not have been overturned. This concludes my right to reply. Thank you, Justices.
This concludes the matter of Armstrong v. Ward. Just a reminder for the judges to email the score sheets as soon as possible, and the instructions can be found in the judge's brief that you were provided with earlier this week. I also invite everyone to remain for the next session, which begins at 11:30 if you'd like to stay and watch. Thank you. Have a good day, everyone.
Thank you.